Good morning, everyone, and welcome to another event in Clause 40 Foundation's series of conversations on emerging scholarship in criminal law and policy. I am Shana O'Toole, founder and president of Clause 40 Foundation. Today's conversation is with Professor Evan Bernick. Professor Bernick is an assistant professor of law at the Northern Illinois University College of Law, where he teaches many things: constitutional law, criminal procedure, administrative law, and legislation. All of the good things, if you ask me. I hope the students there are taking full advantage of the courses that you're teaching, because those are all my favorites. And if you're going to be a criminal defense lawyer, those are the topics you should certainly pay attention to, particularly administrative law. Before joining the NIU faculty, he was a visiting professor at the Georgetown University Law Center here in Washington, D.C., as well as the executive director of the Georgetown Center for the Constitution. He received his BA and his JD from the University of Chicago, and he clerked for Judge Diane Sykes on the Seventh Circuit. Along with Georgetown law professor Randy Barnett, Evan is the co-author of a new book called The Original Meaning of the 14th Amendment, Its Letter and Spirit, which details the development of the 14th Amendment, including the drafting of the amendment and its history of the concepts that it enshrines. The 14th Amendment promises broad protection of various rights, and the book offers an understanding of the amendment that is aimed at better fulfilling that promise. Many of these rights are integral to the criminal legal process, including the right to due process of law, which is the center of our mission here at Clause 40 Foundation and its sister organization, the Due Process Institute. Today's conversation will focus on the relevance of the history and interpretation of the 14th Amendment to the protection of criminal defendants' rights, and with what that history reveals about why these rights matter so much. Now, our goal in this book series is to keep our conversations accessible to interested people of all backgrounds, not just history nerds or constitutionalists or lawyers. So in service of that, I'd like to start by having you go briefly into the broader historical context of the 14th Amendment. Why was it passed? And on paper, how did it broadly change the relationship between the federal government and the states when it comes to the protection of individual rights?
Now, first of all, Shana, it's a pleasure to be here. Thank you for giving that plug for the importance to criminal law of administrative law, which I try to impress upon my students, perhaps with varying degrees of success, depending upon the context. This is the story of the success of one of the greatest mass movements in human history in demanding and insisting upon protections for rights that were systematically neglected and violated over the span of about a century, and the efforts to enshrine an amendment in the Constitution that would ultimately provide not only guarantees for specific rights, but an infrastructure, an institutional commitments to a federal government that would have the size and scope and the constitutional authority necessary to secure those rights, even against relentless state and private efforts to undermine them. It's important to recognize that the 14th Amendment was not something that was part of the original plan of Reconstruction, but a response to a failure of the 13th Amendment to effectively provide conditions under which people who were previously enslaved could flourish. The 13th Amendment famously abolishes and declares that neither slavery nor involuntary servitude shall exist except for punishment for a crime of which a party shall be duly convicted. And Southern states went out of their way, the former Confederate states went out of their way to make what they could of that exception by passing racist and discriminatory laws that systematically disadvantaged black people, now black citizens, in the context of the criminal legal process, criminalizing insulting gestures, criminalizing vagrancy, requiring black people to go around with proof of their employment at the risk of being arrested, imprisoned, and then bonded out to private employers who would work them to death. The 14th Amendment was designed to put an end to that and deliver on the ultimate promise of abolition. And the book is about how the 14th Amendment was drafted, the public campaign for its ratification, and how the constitutional theory behind it emerged out of abolitionist struggle even before the Civil War, which struggle was enabled by and inspired by a recognition of the importance, in particular, of due process rights.
Thank you for that. I think the history of, and obviously we can't do it justice in the amount of time that we have, but understanding the background of a century of Jim Crow, racial terrorism, segregation, all of which both the states and the federal government were in fact failing to prevent. I think that understanding that background is key to really moving forward, having a conversation about what it means in our modern times. For folks who maybe aren't as familiar with the 14th Amendment as they should be, I'm going to go ahead and read the language of the amendment, at least those portions that are really sort of key to what we are talking about now, just to really reset it in our hearts and our minds. Section 1, and I quote, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protections of the laws." And then in Section 5, "The Congress shall have the power to enforce, by appropriate legislation, the provisions of this article." And so now I think maybe it's helpful to go through each of those clauses that you discuss in great detail in the book to sort of unpack how you want us to maybe revise our understanding of those and what some of the implications of those revised understandings will be as applied to our criminal legal system.
Sure. So the first sentence effectively repudiates the Supreme Court's decision in Dred Scott v. Sanford holding that black Americans could never be citizens of the United States by flatly declaring that all persons born or naturalized in the United States are citizens of the United States. That puts an end to Dred Scott. Okay, well, what rights do those citizens now have? They have the privileges and immunities of citizenship, which is a concept that, as Republicans during the antebellum period understood it, included rights that were widespread, deeply rooted in the sense that they were entrenched and were deemed to have proven their worth for an extended period of time, and tightly associated with citizenship. These rights not only included individual rights enumerated, for example, in the Bill of Rights, like the rights to free speech, the right to bear arms, the right to be free from unreasonable searches and seizures, the right to confront witnesses against oneself in a criminal trial, but also rights that were not listed in the Constitution. Common law rights like the right to be free from discriminatory taxation, the right to be punished equally for crimes of which one has been convicted with people of other races, religions, or creeds, and the right to make and enforce contracts, and finally, the right to have access to public institutions that were taxpayer funded to the extent that one was a citizen. Those are the privileges or immunities of citizenship. Now, the Due Process of Law Clause and the Equal Protection of the Laws clauses further secure basic rights for all people, regardless of whether they're citizens or not. Due process of law means a guarantee of certain rights that were associated with judicial process, associated with the common law, although understood in a distinctive way by abolitionists, and also the right to be free of arbitrary laws that didn't serve any legitimate government function. Finally, the Equal Protection of the Laws Clause guarantees not only protection against discrimination with respect to core civil rights, but also protection by the states against private violence. This was particularly important to abolitionists who, even in northern states, found themselves confronted by vicious mobs that destroyed their assembly halls, that destroyed their printing presses, and then in case in one particularly prolific, high-profile case of Elijah Lovejoy, a printer from Illinois, literally shot for publishing abolitionist newsletters. So, not to speak of all the violence that was directed against free black Americans. So we have in the Privileges or Immunities Clause a guarantee of rights associated with citizenship, and in the Due Process of Law and Equal Protection Clauses, guarantees of basic rights that are available to all people.
Thank you. That's very helpful as a framework. So let's sort of dive into each of those a little bit more.
Sure.
The Due Process Clause, where did it come from?
So the Due Process Clause comes from, Clause 40, it comes from Magna Carta. And it, over the course of time, became to be associated not only with a guarantee of certain procedural rights that were associated with the common law, notice, an opportunity to be heard, the access to a neutral tribunal not staffed by executive branch officials, but also a guarantee of law. Law in the sense of a generally applicable norm that punished people for actions that they would subsequently engage in, not that operated retroactively, and law that served public purposes rather than merely the interests or avarice or prejudices of legislators. To be deprived of one's life, liberty, or property, and by life, liberty, or property, meaning bodily integrity, freedom of movement, and access to tangible or intangible assets in terms of property, pursuant to a generally applicable norm that operates prospectively and that serves a function that is truly public in the sense of promoting the general rather than anybody's private welfare.
And as you were defining due process, I hope that people heard a number of rights that should sound familiar, particularly in a criminal law context. We're talking about really trial rights, rights to know the accusations against you, rights to have a trial by a jury of your peers, to defend oneself, ideally. Why were these rights, which in my mind are being eroded quite significantly in the modern day times, why were they so important to the founding generation? Why were they so important to the abolitionists who were influencing the people who were drafting the 14th Amendment?
So those are two very different questions. They were important to the founding generation and they were important to abolitionists for very different reasons, although there are some resemblances between them, as we'll see in a second. So the founding generation, in particular the anti-federalists who were concerned about the new Constitution, believed these rights were important because they had served as an opportunity for localized resistance to British overreaching during the colonial era, and it was the British failure to respect these rights, in particular convening adjudications that were conducted by Crown officials rather than in the presence of colonists and the presence of the community, that really enabled the British to systematically eviscerate what the founders regarded as their heritage as Anglo-American British subjects. They felt that they were not being treated equally to other British subjects in the metropole, that is, in mainland England. Because in mainland England, yes, you had the right to have access to an impartial court, and you had the right to the jury of your peers, but in the colonies, you could be taken away to some remote location and interrogated, sometimes with torture by Crown officials outside of the presence of the jury. Okay, so the Anti-Federalists demanded due process and jury right guarantees specifically because of that experience. Abolitionists were responding primarily to the denial of any process at all in the form of mob violence against themselves when they were set upon by racist mobs. And also, they were complaining about the lack of process and the lack of certain guarantees that they associated with the Fugitive Slave Act of 1850. Fugitive Slave Act of 1850 created effectively a new federal slave-catching agency. You had bureaucrats who had offices in various states who convened adjudications outside of the presence of any jury, where there was no right to confront witnesses, and for which adjudications judges were actually paid differently depending upon whether the alleged enslaved person was found to actually be a fugitive slave or not. They were paid more for concluding that the person was a fugitive slave than not. So there was a powerful incentive, financial incentive beyond anything else, to authorize what amounted to kidnapping. Now, it was in part because of the colonial experience, and in part because of this abolition experience that Republicans who ran in abolitionist circles and also venerated the founders came to mythologize the procedural rights that they associated with due process of law and confrontation and others, and make them much more robust than perhaps they had ever historically been. And they sought to make the 14th Amendment that basically enshrined the guarantees as they understood them, even though, the history, the founders were notoriously played fast and loose with the actual history, but were not bound by the actual history, were bound by how they understood it, because they entrenched their perhaps misunderstanding of the relevant history in the Constitution.
So let's get in our time machine and
Sure.
move forward to today. Do you think our federal government is protecting due process rights in the modern criminal legal system?
More than 90% of criminal trials never go to trial. More than 90% of criminal adjudications, let me be more specific, never go to trial, never go before a jury, because of the development of what's euphemistically called plea bargaining, but what really amounts to coerced agreements that is imposed upon people who worry that if they assert their constitutional rights to go to trial, the result will be greater punishment for themselves than if they just accept the deal that the prosecution is offering. The Supreme Court has said that this arrangement is fully constitutional. As a matter of the original meaning of the Constitution's guarantees to due process and jury trial rights, it's not. Several years ago, Michelle Alexander, the author of The New Jim Crow, published an article in which she argued that people should go to trial and crash the system. Criminal defendants should effectively engage in collective action, demand their jury trial rights, and watch the system crumble. She was effectively right as a matter of original meaning. People are entitled to these rights, and as a practical matter, it says a lot of negative things about our system, that it's even possible for insistence upon constitutional rights to swamp it. So yes, the original meaning of the 14th Amendment would have a huge impact on the operation of the criminal legal system, and to the extent that that would prevent the system from functioning as it currently does, well, such is the price of ensuring liberty as the framers of the 14th Amendments and the original Constitution understood it.
And what do you say to Americans who hear that and think, well, I've not been a criminal defendant, no one I know has been. If you do the famous quote, if you do the crime, do the time, what do I care whether every single one of those people gets a trial? Why should the rest of us care?
What I would say is that reasoning would justify not having any trials at all, because we're confident that an individual person is guilty. The whole point of having a trial and convening a jury is because we are confident that those processes will actually yield the truth of the matter. And to the extent that the jury is involved, as they are constitutionally guaranteed to be, it's actually a little bit more than that. The jury is not, as the founders and the framers of the 14th Amendment understood it, supposed to be a passive determiner of the facts of the matter. The jury is also supposed to judge the law, the constitutionality of the law, and even the morality of the law in deciding whether to impose punishments. Particularly, the morality parts can strike people as antithetical to the rule of law, but to the extent that it is part of the original meaning of the constitutional amendments that we're talking about, we have a supreme law of the land that requires that. The question of what the rule of law is just begs the question of what law we have, and in this country we have law that gives ordinary people, in the form of juries, a great deal of say over how and when people should be punished.
And we really have lost that citizen participation in the determination of what our laws are. We really have lost that.
Excellent.
The section in your book on the Equal Protection Clause argues that the clause creates an affirmative duty for states to protect citizens' rights from infringement even from private actors, which brings along with it a power for Congress to provide that protection when states fail to do so. At the time, the most pervasive example was, of course, lynchings and other privately committed but state-tolerated or even state-endorsed violence aimed at the subjugation of Black Americans. But what would this duty of protection look like today? Does it have implications for any common criminal justice practices, for example?
So it might do things like suggest that the Supreme Court was wrong in the United States v. Morrison in holding that the Violence Against Women Act, which authorized civil remedies for victims of gender-motivated violence, was unconstitutional because it didn't target state action, it targeted private action. Making your way through the history, it becomes abundantly clear, both in the form of what abolitionists were complaining about when they invoked equal protection and demanded equal protection, and what Republicans did following the ratification of the 14th Amendment by way of enacting civil rights legislation that was designed to protect Black Americans and their white allies against violence, that there was no state action trigger for the 14th Amendment's Equal Protection Clause, even though with respect to the Privileges and Immunities Clause and Due Process of Law Clause, you really do have a no state shall abridge nor deprive state action hook. So how does this get operationalized? Does this mean that judges are now going to be in the position of determining how a municipality should spend its money on law enforcement versus other social priorities? I do not argue that that would be either a constitutionally necessary or even desirable way to go. I do think, however, that Congress that Congress is able to legislate in a prospective way with respect to civil rights that is not just informed by the particularities of a given case, but can look across cases in ways that don't raise the same concerns that an individual judge deciding how much a municipality should spend on policing would.
Right. As someone who is skeptical of the current criminal legal system, do you worry at all that the broader recognition of a duty of protection would be used to justify even further expansion of our criminal legal system, given that the way our communities seem to, and our lawmakers certainly seem to understand protection today is mostly relying on policing and, in fact, incarceration?
Yeah, this is a very serious concern, and it's one that's been heightened by Naomi Murakawa's work focusing on the degree to which liberal calls for protection, particularly during the early 20th century, lent themselves to arguments for bigger, more robust law enforcement. Protection really is a vexed concept. My response to this concern, though, is that this is really an argument that we're already having, and people who argue for the expansion of the carceral state do not need further constitutional ammunition to spend. This is something that one finds in the history if we're going to be committed, or we think that the history is instructive about how we should understand these guarantees today. We need to reckon with it for good and for ill. And just by way of specifics about having this discourse, I don't think that the Equal Protection Clause needs to be read in a way that justifies a commitment to more policing, and in fact, to the extent that more policing actually leads to more state violence and less protection against private violence, it is open to, and I actually argue that those of an anti-carceral persuasion should draw upon constitutional resources, including the Equal Protection Clause, to say we should reduce the footprint of the carceral state.
Thank you. And so now to the Privileges and Immunities Clause, which was essentially read out of the amendment soon after ratification. How do you propose we understand that now instead?
So the Privileges or Immunities Clause includes a number of guarantees that the Supreme Court has already recognized under the Due Process Clause. The fundamental rights that the Supreme Court currently protects, like the rights to, the right to bear arms, the right to freedom of speech, the right to be free from unreasonable searches and seizures, those would basically all stay much in the same form that they currently are. But the sets of possible privileges or immunities would be open. It would be possible to develop rights over the course of time that, if they catch on in enough states and they stand the test of time, to become privileges or immunities of citizenship. The set would not be closed either by what was going on in 1868 or what the Supreme Court thinks is, all things considered, best. I hasten to add that this would not see the courts on its own initiative just creating new rights because it thinks that that would be a good idea. The court would be charged with looking across the states, looking to the positive law of the states, and determining whether a right has been embraced by a supermajority of the states for 30 years. So it's both demanding, but it's also allows for the expansion of rights in ways that the framers of the 14th Amendment's own experience with rights contemplated. They saw rights develop and show their worth over the course of time, rights like due process of law, the right to confrontation, and they saw rights become more and less important over the course of time. So I do think that we should be committed to the idea that the set can expand, although it cannot contract.
And how would this reading of yours change the way the federal government is securing these rights held by, or at least relevant to, criminal defendants today?
It would give Congress more space to legislate to ensure that criminal defendants' rights are protected in the states. It would give federal judges more power to ensure that not only rights expressly listed in the Constitution, but those that are criminal defendant friendly and those and show their worth over the course of time can also be imposed. So suppose there were to be a movement across the states concluding that wealth-based jailing is unconstitutional and has no place in a republic that's dedicated to the notion that one's financial standing should not determine whether one ends up in prison. It would be possible for a judge to recognize that that consensus had developed over the course of time, that it was entrenched, and it is now part of the privileges or immunities of citizenship not to be jailed because one is unable to pay a fee.
I wonder if the bail reform advocates are sitting and reading your book and understanding how helpful your constitutional argument would be to some of the advocacy they're trying to accomplish.
The way I see it is that, like, the boundary between policy arguments and constitutional arguments in America is very permeable. And if one side is not prepared to make those arguments because they're concerned that the Constitution is just too regressive to help them, the other side is just going to dominate the discourse by saying, we have the Constitution on our side and you're making policy arguments. And that is not a position that one wants to be in to the extent that we have a democratic republic, because we're just going to get beaten every time. And by we, I mean those of an anti-carceral persuasion.
Indeed. The 14th Amendment, as we discussed, grants Congress the power to enforce its commands by appropriate legislation. You've made an interesting point in your book about how the Supreme Court has at times limited the rights they're willing to recognize in Section 1 because the courts have limited powers to actually enforce the rights. But in doing so, the court has artificially narrowed the power of Congress, a separate branch, which has much greater and varied powers to enforce rights, but isn't being allowed to enforce those rights that aren't recognized by the court. So we appreciated this point both because we're very passionate about individual rights here and about Congress and Congress's role, but also because we remember multiple times, many of our staff have been congressional staffers, and they have been in the process of drafting bills to protect enumerated rights against state and local government violations, particularly in the criminal justice space. But the ability to do that is often frustrated by the Supreme Court's Enforcement Clause precedents. Right. So, on that point, you are using the Enforcement Clause to breathe almost more life into these other amendments, to the other clauses in the amendment. And I'm curious to see if your work is, do you see your work as changing the way we would understand the enforcement clause? And if so, what does that look like in this criminal justice context?
Well, I hope it does, but I would also hasten to add that the idea that the Supreme Court's reading of Section 5 is actually quite out of step with what Republicans designed Section 5 to achieve, and specifically empowering Congress to specifically legislate broadly in protection of civil rights in ways that outstrip what the court would do itself to enforce civil rights is not new. I mean, so this goes all the way back to Professor Michael McConnell, noted originalist critique of City of Bernie v. Flores, in which the Supreme Court held that the Religious Freedom Restoration Act couldn't be applied to the states because because Congress took a slightly different view, or significantly different view, of the free exercise of religion than the court itself had in a prior case. Now, obviously, Congress can't make rights up and claim that because Section 5, we're going to just restrict the states from doing a bunch of stuff. But that's very plainly not what was going on with the Religious Freedom Restoration Act. There was a difference in degree, not in kind, between what the rights that Congress was trying to protect and the rights that the Supreme Court concluded existed in the Constitution. And I see myself as kind of adding to a chorus of voices saying that what the Supreme Court is doing here is really animated by vague notions of federalism that are very removed from the context of Reconstruction, rather than a serious engagement with original meaning. And to the extent that the Supreme Court's originalists call themselves originalists, that should matter. And I think that there are some justices who really do take this stuff seriously in the criminal justice space. They get into long arguments about the original meaning of due process with respect to void for vagueness doctrine. This is, Demia with Gorsuch and Thomas going at it. And I think it's high time that they be prepared to revisit this issue too. At the time that these key decisions were made in the early 90s, originalism hadn't quite become ascendant in the way that it is now, so there's always an opportunity to refocus the court's attention. Now, is that optimistic beyond the evidence presented? Perhaps, but at least at this point, I am prepared to assume, if not good faith, there is value to just heaping up evidence on the other side and pointing at it repeatedly.
Surely some people who self-identify as originalists must be challenging your understanding and definition of what it means to be an originalist.
Yes, they do. And the most that I can say on that score is look at the evidence presented. Andy and I wrote a 476-page book, and we have been engaged on the merits of our arguments. We had a debate with Professors Ilan Werman and Christopher Green, and I was just at an originalism conference last week in which that debate was reprised in person where it had already been in print. These debates are going to continue, but we do share a common commitment to a methodology. We did check all of our notes. This is what we're going with. And, all I can say is that because this methodological commitment is something I take seriously, I'm willing to update my views on the basis of new evidence, but I think I've got it right.
You're still convinced.
You
and Randy
convinced,
are still
yes.
convinced. Excellent. What do you think Congress could do to enforce the 14th Amendment under your understanding that they aren't or can't do right now?
So one thing that they could do is actually focus attention on municipalities that either engage in civil rights violations or fail to protect people against private civil rights violations in ways that they haven't thus far, because the DOJ tends to take its position on what it can do by way of enforcing the 14th Amendment by looking to what the Supreme Court itself has said. Right. Pattern and practice investigations that the DOJ can conduct into patterns and practices of constitutional violations you need to determine what's a constitutional violation. And if what the Supreme Court has said is that only state action leads to constitutional violations, that does hinder what states or what the DOJ can do. So Alexander Natopov has written of under-enforcement zones, places in which places that are neglected by law enforcement, as well as places that are over-policed by law enforcement. That whole area of law enforcement policy is effectively relegated to the realm of policy rather than something of constitutional salience because of the state action doctrine. So there are a number of things. The other thing that Congress could do is the Supreme Court has said that it is permissible for the purposes of enforcing certain kinds of civil rights legislation to depart from, in passing regulations, what the Supreme Court itself has said about discriminatory intent in the 14th Amendment context. So that means that there are certain areas of law, statutory law, where Congress could say on the basis of a disparate impact analysis, there's a problem here. And they could do so based in part on the constitutional conviction that discriminatory intent actually isn't required by the Constitution, as I argue. But the Supreme Court has also left doctrinal space for them to act on that constitutional conviction. So gradually we get this idea that disparate impact can serve as a touchstone for identifying civil rights violations normalized.
Well, I have to say, I'm personally very excited about your understanding, sort of recontextualizing of these clauses, and I've enjoyed the book. I think it's a great read. I highly recommend it. And I wanted to give an opportunity to our live in-person audience to ask any questions that you might have. We have someone in the back who has a microphone, so if you just want to raise your hand, if you have questions, comments, and she'll come to you. We want to use the mic so our folks at home can hear your question or comment. Go ahead.
Thanks. This was a great discussion. Early on, there was a question referring to the erosion of our due process rights. And I'm probably less expert than everybody else in the room, but I wondered when I heard the question, are they really eroded compared to earlier eras? And then, in response to a different question, you mentioned the court's jurisdiction on free speech, the right to keep and bear arms, and the right to be free from unreasonable searches and seizures. In all of those areas, have not our rights become more secure because of court rulings over the past generation?
There was no halcyon period in which the original meaning of the Constitution has been relentlessly and consistently enforced. And when I emphasize that I don't think the Supreme Court is giving us everything that the 14th Amendment promises, that's against a baseline that recognizes that the 14th Amendment really does require some radical commitments, and that the Supreme Court has actually, in certain respects, been pretty good as measured against previous courts in certain respects as well. But to just go with your example of the Fourth Amendment, the fact that we have this subcategory called reasonable suspicion that allows police officers to stop and frisk people on the streets, to search and seize people on the streets, is something that you have absolutely no historical foundation for, either at the time of the ratification of the 14th Amendment or at the time of the ratification of the Fourth Amendment. The Supreme Court basically made it up because it concluded that that would actually strike the right balance between crime prevention and individual rights at a time where the crime rates was historically high. So for all that I celebrate certain Supreme Court decisions that actually have, as measured against a historical baseline that's not pretty good, improved upon the Supreme Court's previous doctrine, there are some real limitations that do have a tremendous impact on people's lives, and I would prefer that the law change accordingly.
I mean, we also are seeing the Supreme Court really struggle with applying the Fourth Amendment protections in our electronic and digital space. Right? They've been slow to respond to that. It's been inconsistent. We still actually there's still sort of a question or concern about how much our records, that particularly electronic records that are kept by third parties, are being protected, and yet they are really quintessentially our papers and our things that certainly, I think, even the founding generation would have understood are of the content of things that should be protected from government surveillance without a warrant.
Absolutely, and just to go off the point about due process a little bit more as well. In Ramos v. Louisiana, the Supreme Court holds that unanimous juries are required in the context of felony convictions. Great, wonderful. Next, do something about plea bargaining. So it's not a matter of saying the Supreme Court is not doing anything right. It's fitfully doing things that are right, but there is a great deal that the Constitution promises that we're not getting, and I suppose I'm greedy for full fidelity to this text that everybody venerates, particularly those who say that they are full-bore originalists about it.
So I'm going to challenge you there, because on my, in my other day job, I wear a hat as an advocate and, in fact, a lobbyist for the Constitution at the Due Process Institute. We advocate for legal reform in the halls of Congress. And we recognize that the plea bargain state that we currently use in the system has gone too far. It's not protecting rights. It's not getting us to the right answer. It's leading to erroneous convictions. It's leading to a lot of harm. It's leading to over-incarceration. How do we fix it? This isn't the subject of your book, but since you're sitting here in front of me and we're talking about the plea bargain state, what on earth do we do? It sounded like you might have been a proponent of put the system to its test, have it collapse and start over. Is there, I don't want to put words in your mouth, do you support that as the way to get us to a place where we can reset the system and introduce more fairness and due process for the vast majority of citizens that are being put through the criminal legal system? Or is there something else we could do to change the system?
We did not get here all at once because of any one particular thing.
Right.
There's a reason that plea bargaining developed in the context that it did. There are structural reasons that led to the broad criminal laws, the broad prosecutorial discretion, and the elimination in certain respects of traditional due process rights. And traditional, again, you have to be careful with that, because due process itself is an evolving concept that has been fitfully honored. So the answer to this question is one that I think that people of an anti-carceral persuasion can reasonably disagree about, so long as we are confident that we are working ultimately towards the same ends, which is a state that actually ensures that people who are subject to the most severe penalties that the state can impose really have been subjected to a rigorous fact-finding process, strong adversarial testing, and the judgments of their peers about how state violence should be deployed.
Agreed. And of course, that doesn't mean that plea bargaining should be outlawed completely or prohibited completely. You probably recognize that there might be an appropriate place to allow someone who is accused to knowingly and voluntarily plead guilty in order to perhaps receive some sort of benefit from giving up their incredibly important rights. But it sounds to me that you are someone who thinks that 90% of the people who are being accused shouldn't be really defaulting to that position.
It's very difficult to tell somebody who is in a position where they can be reasonably certain that if they exercise their constitutional rights, they will be punished for it, that they should do that for the sake of constitutional integrity, even if by constitutional integrity we mean something that benefits everybody else. So I always try to draw a distinction between what I would advise any given person to do and what I think should systemically change.
Right, and that is really the catch-22, I think, for people who are representing people on the ground, who are stuck inside of the system, who cannot change it, who intellectually want to change it, who advocate in their free time to change it, but who are sitting there across the table from a client. And they are being offered exactly that option. Bargain away your rights, and you will see your family slightly sooner, or you will keep some of your property or your money sooner, or perhaps somebody in your family won't be indicted or accused.
Yeah.
And it's very difficult for a criminal defense lawyer in that case to say, stand your ground and defend your own constitutional rights when great harm could come at them, could come because of that decision.
Absolutely, but the only thing that I would add is that the fact that the system puts people in that position is a problem that we need to address on another level, even if in that particular context somebody should be informed about the options that are actually available to them and would benefit them given the system as it is.
Absolutely. Are there other questions or comments from our audience? Yes.
Hey, Tommy Berry from the Cato Institute. I wanted to ask about the interplay between the Equal Protection Clause and the Privileges or Immunities Clause. I was really intrigued by the way you described the Privileges or Immunities Clause as potentially enshrining rights that a supermajority of states have recognized. And that sort of contrasts to how I've always thought about the Equal Protection Clause as purely about intrastate equality. In other words, even if 49 states recognize a certain right, the 50th state could not, for example, some libertarians argued that a state could get out of the marriage business entirely and then would not have to recognize same-sex marriage under the Equal Protection Clause. Would it be too simplistic to say that the privileges or immunities is sort of about interstate equality, whereas equal protection is purely about intrastate equality? Or do you think that, to some extent, they overlap a bit, or that equal protection could also have an element of interstate equality?
So this is a really complex question, but a really good one as well. Equal protection does seem to have been viewed as itself a privilege or immunity of citizenship. It just happens to be something that is also generally available to all people in virtue of their humanity. Citizens, being human, get the basic rights that all humans get. They just get some additional ones as well. With respect to the question of interstate equality, I do think that that can be a useful way of looking at it, particularly since the Equal Protection Clause, it applies to the states. It says no state shall deny anyone the equal protection of the laws. So by definition, we're talking about something that is operating either in a discriminatory way within a state or just totally failing to provide protection for a civil right within that state. With respect to the privileges or immunities of citizenship, I do think that you put your finger on something important about the supermajority formula that Randy and I have articulated, which is, yeah, it is supermajoritarian. It's possible that one state would be an outlier with respect to the value of a certain right and then effectively lose out as a constitutional matter because of it. Like, it's possible that a tide of states would agree to something absolutely ridiculous, fill in the blanks. And then we would have, like, that ridiculous thing guaranteed as a matter of constitutional law. But what I would say to that is, like, that's built into the supermajoritarian process through Article 5 anyway. So we're not talking about something that has pathologies or problems to it that also don't apply to any constitutional amendments. You may think that certain current constitutional amendments are pretty stupid, but we're stuck with them as a matter of constitutional law. The final thing I would say with respect to that is the formula that we come up with for the recognition of additional rights is actually more demanding than the one that the court currently articulates. And it's also less manipulable by judges. So right now, to recognize a new fundamental right, it needs to be deeply rooted in the nation's history and tradition. Okay, how many years? How deeply? How long? We don't know. The Supreme Court has never specified. So our privileges or immunities formula has the virtue of specificity, even if at a certain point the distinction between, say, 30 years and 31 years is arbitrary. At the edges, all legal rules are.
Another question? All right, then I will exercise moderator's prerogative. The story of the 14th Amendment is one of triumph followed by tragedy. Our failure to enforce its guarantees have enabled state-backed subjugation of black people in basically every facet of society for almost another century, until the court and Congress, prompted by the efforts of the civil rights movement, began to better vindicate its guarantees beginning in the 50s and 60s. But now we find ourselves in what has been deemed as the new Jim Crow, which is a state of mass incarceration, particularly of black and brown people. Millions of them, our fellow citizens, black and brown people, are under some kind of government correctional control, whether it's prison, actual jail, probation, parole. And yet at the same time, our governments seem to be failing to provide protection from various types of violence and exploitation and poverty in black neighborhoods, and instead are possibly and likely contributing to it. I'm going to be provocative. How has the Supreme Court's 14th Amendment jurisprudence really played a role to enable mass incarceration?
It's played a role to enable mass incarceration through a number of decisions that it has made in the criminal procedural sphere that have given very broad amounts of discretion to police and to prosecutors, and also in its development of doctrines that insulate both of them from liability for constitutional injuries. So I've talked about Terry v. Ohio, which legalized stop and frisk. I didn't mention Wren v. United States, in which the Supreme Court held that all that one needs for a traffic stop, as far as the Fourth Amendment is concerned, is probable cause to believe that a traffic violation has been committed. Sounds kind of okay until you realize that virtually everybody breaks the traffic laws at some point, and that the court has effectively excluded from constitutional inquiry any investigation into whether particular decisions to make stops are pretextual.
And to put too fine a point on it, I mean,
yes.
that decision, the Wren decision, effectively blessed and condoned racist policing practices.
Yes, it did.
There is no way to look closer at those policing practices and determine whether they are unconstitutional.
Right, and this is exacerbated by the apparent, the apparent backup that Justice Scalia articulates in that opinion. He says, look, there's still an equal protection clause. Okay, but the equal protection clause requires discriminatory intent. Okay, discriminatory intent can only be proven through an incredibly rigorous process that makes it effectively impossible to determine whether an individual police officer discriminated intentionally. Okay, so we have the appearance of constitutional protection and the reality that pretextual stops are absolutely fine where the court is considered. And this is not the only example. They could be multiplied. The development of qualified immunity, something that has no foundation in the text or the history of the 14th Amendment or really anything else, that effectively says that even though the primary statutes that congressional Republicans developed to authorize Congress to authorize individuals to sue for constitutional violations says nothing about immunities that officials enjoy. Nonetheless, because we're worried about the poor cop on the beat being mulcted of his assets, according to the Supreme Court, we're going to make this up. So it's one thing after another thing after another. And even the decisions that sometimes seem to be anti-carceral get narrowed and limited in ways that effectively make their impact quite minimal.
Professor Bernick, I cannot thank you enough for this conversation. I think your book is fascinating. I think the information you're putting in our hands is imperative to wrestle with, to grapple with as a modern society, whether you are a criminal defense lawyer or not, whether you're a conservative, a libertarian, a progressive, somewhere in between, depends on what day of the week, you can't decide what you are. So thank you for writing it. Thank you to Mr. Barnett, for your co-author, for writing it. I recommend it. How can people get their hands on this book?
Pretty much anywhere books are sold.
Right.
So yeah, it's everywhere. You can find it pretty easily.
Excellent. And with that, do you have any final words you'd like to say?
Thank you so much, Shana. This has been a great conversation, and thank you all for being here today.
Appreciate it. Thank you so much for joining us.
Thanks.